Where do I even start? If you're handling a loved one's estate in California, you're not alone. Most people taking on the role of an executor or personal representative are doing it for the first time, often during one of the most difficult seasons of life. Grief and family pressure can all hit at once. That's why we strongly recommend consulting with a probate attorney and a trusted financial advisor early in the process. Their guidance can help you avoid costly mistakes and make confident decisions for your family's estate. We're here to walk you through the required steps for probate in California, especially for homes and assets in Orange County. We'll break down the court deadlines, paperwork, common mistakes, and what happens if you miss a step. We'll also explain how to protect the estate, keep the peace in your family, and avoid delays that can drain time and money. Leave a comment below if you would like us to address any of your concerns. This isn't just the legal process, it's emotional. That's why we focus on education, empathy, and estate protection. And we guide you every step of the way. Let's begin with what probate requires. In California, probate is a court-supervised process that settles the estate of someone who has passed away. It's not automatic, it's not instant, and yes, it comes with required steps and strict deadlines. Here are the core California probate requirements. Step 1. File a petition for probate. This is how you start the case. You file in the Superior Court, usually in the county where the person lived. In Orange County, that means the Central Justice Center in Santa Ana. You'll request to be appointed as the executor if there's a will, or administrator if there's no will. The court sets a hearing 35 to 45 days out. Step 2, notify heirs and beneficiaries. You must send legal notice to all interested parties, including siblings, even estranged ones. You will also publish notice in a local newspaper. Deadline. Notices must go out at least 15 days before your hearing. Step 3, get letters from the court. Once appointed, you'll receive letters, testamentary, or letters of administration. This gives you legal authority to act on behalf of the state. But don't act too fast. You'll likely need a probate bond if the will doesn't waive it. Court instructions on limited versus full authority under the Independent Administration of Estates Act. Step 4, inventory and appraise assets. Within 4 months, you must file an inventory and appraisal listing all known estate assets and their value. A probate referee, appointed by the court, helps assign values. What happens if you miss a step? Penalties and probate delays. Now let's talk about consequences. Many families think probate is just paperwork and wait time. But if you miss a requirement or do something out of order, the court can delay your authority to sell property, deny reimbursement of out-of-pocket costs, freeze bank accounts, fine the estate, remove you as personal representative, and remember, you can be held personally responsible if something goes wrong. Let's say you clean out the house and toss some items before the appraisal, or pay for repairs from the estate without notice to heirs. These things seem small, but in probate court, they can trigger a formal hearing or even litigation. That's why we build a custom timeline for every family we work with. After your attorney outlines the key court dates and filing deadlines, we step in to help you stay organized. Our job is to make sure nothing slips through the cracks, that you meet every deadline, stay compliant, and avoid the kind of confusion or accusations that can cause tension among family members. It's about keeping the process smooth, transparent, and stress-free. Let me share this story with you. A woman in Orange, California, we'll call her Diane, was appointed administrator for her father's estate. No will, one house for adult siblings. Diane filed the petition correctly, but she didn't know about the 15-day notice rule. She mailed notices late. Her court hearing was delayed by another 30 days. Then she forgot to file proof of publication for the legal ad. That pushed the timeline again. 6 months passed before she was legally allowed to list the home. And by then, the market had shifted. Interest rates went up. 2 buyers backed out. Her brother blamed her for the delay, and a once civil process turned bitter. Diane wasn't careless. She was just overwhelmed. She had never done this before, and no one explained how one misstep caused a chain reaction. We stepped in and connected with her with a probate attorney, someone who could guide her through the legal steps and make sure she didn't run into compliance issues again. With that support, she gained full authority under the Independent Administration of Estates Act, which meant fewer court delays and no penalties for missed deadlines. From there, we secured vacant home insurance, arranged the full cleanout, and made sure the property was safe and market ready. Once the home finally hit the market, we received 3 solid offers right away, and she was able to move forward with confidence. But the emotional toll, that couldn't be reversed. This is why probate guidance isn't just legal, it's personal. There's a basic list of documents you'll need for a typical probate case in California. Some will be filed with the court, others are kept for records. Court filing documents. Petition for probate. Notice of petition to administer estate. Duties and liabilities of personal representative. Proof of service to heirs. Letters testamentary, inventory and appraisal, final counting, unless waived, petition for final distribution. Supporting documents, original death certificate, original will if there was one, trust documents if partial trust involvement, property deeds, bank and investment account statements, list of personal property, furniture, jewelry, vehicles, etc., insurance policies, mortgage, and utility bills. We always recommend scanning and organizing these in a cloud folder, labeled by date and document type. When families are disorganized, it creates tensions, and when documents are missing, probate can stall. We offer a free checklist to help families stay on top of the paperwork and the timing. Just let us know. Here's a simple roadmap to stay on track and meet California probate requirements. Secure the home. Change locks, notify insurance, cancel unnecessary services. File early. Don't wait months to start the petition. Start gathering documents while grieving. It's okay to ask for help. Notify the right people. Send legal notice to every heir and interested party. Use certified mail and keep proof. Track every dollar. Keep a ledger of estate expenses. Don't pay for major repairs from the state without approval. Follow the court's timeline. Post bond if needed. File inventory and appraisal within 4 months. Don't distribute assets until court approval. And most importantly, communicate with your siblings. Even if you're the one doing all the work, it helps to explain the timeline and answer questions before they turn into assumptions. Need help managing the California probate process? We help families navigate probate from start to finish with clear guidance, local expertise, and a team that cares. Leave your questions or share your experiences in the comments below. Your insights help our community grow and learn together. Whether it's your first time as an executor or you're overwhelmed with paperwork, we're here to help. Based in Orange County, services include probate home preparation and sales, full cleanout and contractor coordination, Zoom calls with family members, trusted referrals to probate attorneys and CPAs. Probate doesn't have to be scary, but it does have to be done right. When you're grieving a loss, the last thing you need is a legal headache or family conflict. Our goal is simple: to guide you to protect the estate and to help your family move forward. You don't need to know everything. You just need to know where to start and who to trust. We're here when you're ready. I'm not an attorney or a financial advisor, and I highly recommend you consult with a probate attorney and a financial advisor professional early. They can provide insights into the most cost-effective methods of settling the estate and ensuring compliance with California law